SJC-13545 in the matter of Edward A. Sargent.
Okay, Attorney Fallon.
Morning, Your Honors. My name is Thomas Fallon. I represent Ed Sargent. Ed Sargent went to law school at night. He worked as a paralegal for law firms at the time. He was admitted to practice in 2002. In 2002, he went to work for Siegel, Edelstein, Bissoni, and Fallon in Beverly. I am the Fallon of Siegel, Edelstein, Bissoni, and Fallon. He left in 2005. He's been a solo practitioner since that date. We're here today on an appeal of a decision from a single justice upholding the disbarment of Mr. Sargent. And the first thing I want to stress is I'm in no way excusing that Mr. Sargent took money out of his IOLTA account and used it for his personal use. I don't want that construed in any ways that I'm excusing that. I'm here today because I'm trying to explain what happened. And basically what happened is, and it's set out in the record, and the hearing committee even found that Mr. Sargent had some troubles in 2017 and 2018 with his parents. Parkinson's disease, elderly. They moved back from Florida to Beverly, and he had to take care of them. And as a result of taking care of them, he had to give up his criminal practice. And in his criminal practice, he was receiving checks twice a month, and that was sustaining him. He could no longer do that, so he was relying on his personal injury practice. At the time all this happened, he was in dire financial straits. And I'm not saying that to excuse what he did. I'm saying that because sometimes when you're in dire financial straits, and the hearing committee found he did, and you can't pay your rent, and you can't pay your mortgage, and you have no money to survive, sometimes that clouds your judgment. This is a far different situation where we have somebody working for a firm or a state office that is receiving a regular paycheck, has sick leave benefits, personal leave benefits, and is not dependent.
Counsel, how do you reconcile our case law on ordinary mitigation and exceptional mitigation?
I'm sorry, Your Honor.
Ordinary versus exceptional mitigation. How do you reconcile our case law as to the demands placed on the by Mr. Sargent by his these illnesses?
Well, I think what happened, and the hearing committee, agreed that these things happen, should count as mitigation for his conduct. I mean, because it's
right. Were this a criminal case, we would consider mitigation. But here, our case law distinguishes between the things that happen to people and personally, which can be unfortunate, and exceptional mitigation. And I want you to reconcile our case law on mitigation.
Well, Your Honor, the case law on mitigation, it seems to look into all different situations. When you look at the cases, some of the conduct seems to be excused by giving an indefinite suspension, some doesn't. Sometimes they're giving credit to some of the mitigation factors, and sometimes they're not. They gave credit in this situation for what Mr. Sargent went through, but for some reason, even though they acknowledged that, they didn't connect that to the misconduct. But this is, this is the first time the only time that he's been accused of taking somebody else's funds from his IOLTA account, and also this is the only time he was in the dire financial circumstances that he was in. It did not happen in a vacuum.
I thought there's some issue about the timing. The board doesn't quite find the timing lines up, right? The timing of his financial distress and his misconduct, right? It doesn't neatly coincide with his parents returning from Florida, right?
Well, it's the same year, Judge. It's 2019. The board the board said that this happened in January 2019, the misuse, and the board was saying that it
When did
seems
his parents come back from Florida?
they came back in 2017. And he gave up the criminal practice at that time, so he didn't have the criminal practice going on in 2019. The board said that they had a question of timing on what part of 2019 this happened in, but we're all focused on the same year. It definitively happened in 2019. There was some eviction notices at the end of 2019, but you know, that didn't, I mean, the testimony, the uncontroverted testimony of Mr. Sargent was the dire financial circumstances, which the hearing committee did find. They just didn't connect it to the misconduct, if you will.
But if we were to find mitigation for dire financial circumstances, isn't that the case that people that steal from IOTA and clients are usually in dire financial circumstances?
Not all the time, Judge. Believe it or not, there's people that steal just because they steal. But again, that doesn't mean that, you know, that the courts, when we're dealing with somebody's livelihood, we're dealing with someone's career. Because after all, I mean, being a lawyer is not just a job, as we all know. It's part of us. It's our essence. And you can't use a one-size-fits-all. You have to look at the situation. And there's no question in this situation that that he was suffering dire financial circumstances at the time he took this money that was later repaid. And I just don't think you know, Office of Bar Counsel is urging that, you know, there be a rule, if A, then B, if B, then C, and that's just not fair. That one size fits all doesn't apply to all situations. But that's one of the arguments. The other argument has to do with the so-called deprivation of funds, all right? And we're all over the place on that. At the time, the restitution was made to the client. No question about that. Bar Counsel says that's not restitution because that's the wrong person. Now, at closing arguments at the hearing commission, Bar Counsel at that time said returning the money to the client was the right thing. Now Bar Counsel is saying in brief that the money should have been returned to Mass General. The PIP check in question was received on January 24th, 2019. On February 24th, 2019, Mass General sent a letter to the client saying that there's no patient liability. They had wrote it off at that time. So arguably, if Mr. Sargent gave the money back to Mass General at this time, Bar Counsel could still argue that restitution wasn't made because the money shouldn't go to Mass General.
I'm just a factual question. I thought the money, and you're more familiar with this than I am, so this is really a fact question. I thought the money was to go to Mass Health.
No, Bar Counsel is arguing that the money should have gone to Mass General, the provider.
Well, they're arguing that we have to look at multiple points in time, and I had a question about this. So they're arguing that when the money came in, it's from the insurer, it should have immediately gone to the providers. At that point, it was payable and due, and it was on the basis of the provider's bills that the $8,000 was paid. That's correct, right?
But that had been paid by that time. So the PIP check came in on, the record is a little unclear. The PIP check came in January 24th. 1 month later.
That's the $8,000 came in January 24th.
2019.
1 month later, the client is being told, you have no bills at Mass General. But what about the airlift?
Same thing. They had, all these bills were incurred up to December of 2018.
But I'm sorry, but if he mishandles the PIP payments and say they should have gone to the air ambulance or Mass General or a combination, the bottom line is he can't take the PIP money and use it himself.
No question about that, Judge.
Right, that's the violation.
No, that's the violation. But then they're arguing in regards to the sanctions. It depends on whether funds were deprived or not, and whether restitution was made. And again, I mean,
Is that right? Or I thought they're saying there's no doubt he intentionally deprived people of money, and the presumptive sanction for that is indefinite suspension or disbarment, right? He's going to stand up in a second. I believe he's going to say intentional deprivation of money, and you've recognized your client intentionally did that, right?
but he's also going to say there's no restitution
Well,
made.
that's the second part, which I'd like you to talk about, because we've asked for briefing on how do you distinguish between indefinite suspensions and disbarment, and it seems like restitution is going to be the key element to that when there's intentional deprivation. So
Yes,
if you
sir.
want to, why don't you address both points for us a second? Is there any doubt he intentionally deprived money that belonged to someone? He took money that belonged to someone else and used it for his own purposes.
But my understanding of the word deprivation is it doesn't mean that. And if you, and the reason I say that, Your Honor,
I'm not sure your understanding matters so much as what the case law and the bar discipline decisions, they describe this as classic case of intentional deprivation, don't they?
well, if you look at the Long case and the Wilkershire case, in both cases, they found misuse without deprivation, and in both cases, the attorney took money from the trust fund's account and used it for his own purposes. So I'm not sure how there's no deprivation in those cases, and there's a deprivation in this case. My
Well,
understanding...
isn't it because there was a bill due and it should have gone out to the providers?
Excuse me, Judge?
I thought that the deprivation argument was that there was a bill due and that the $8,000 should have gone to the providers.
But see, there was no bill due, and that's the whole problem here. My understanding of the word deprivation is the funds are due to somebody at a certain time, and they're withheld. Under the PIP payment, there's 2 years. So Mr. Sargent could have, and he didn't.
No. There's 2 years under the statute to make a claim for PIP money. That's different from when you have to pay a bill that the hospital sends you. Can you just assume, for purposes of your argument, that because the fact that they ultimately wrote off some of the bills does not mean that those bills were never due? So can you just assume that the money should have gone to the providers when it came in because there were bills? And so we're just assuming that there was money that should have gone out at that point. And switch to the question of mitigation, of restitution. So the money should have gone to just assume, and I'm not asking you to concede, just assume that it should have gone to the providers in January of 2019 immediately. Okay, hold on.
Okay.
So he didn't do that. A lot of time passes. What should the restitution, what form should the restitution have taken when he eventually decided to make restitution? How practically should he have allocated the $8,000? I understood your brief to concede that it was not the right thing to just give it to the client. Do you agree with that?
It depends on the timing, Your Honor. What?
Well, I'm asking about the timing here, where he learns of this matter and he's okay, I'm gonna pay it. What should he have done when he decided to write the check?
When this matter arose, I believe what he should have done would have been send a letter out to USAA and Mass Health and let them decide who the money should go to, because it's clear in my mind that the money should not go to Mass General, who wrote this off. It should go back to one of the insurance companies. But my understanding under PIP is that there's 2 years, it covers 2 years of bills. So arguably, that money would not be returned until December of 2020. But if no further bills came in to the client up to December 2020, then the money should have been returned. But when this whole issue arose, it wasn't December 2020, so that money wasn't due anybody, and since it was due, there's no deprivation. And again, I'm not saying that the money should have been taken from the account. It shouldn't have been taken from the IOLTA account. It's just that there was no deprivation.
But should you
due to the
get
town
credit
limit.
for restitution when you don't, you don't pay any restitution until basically they're chasing you? They filed your client.
Yes, sir.
We have to decide whether indefinite suspension or disbarment is the right sanction, probably here. And they're going to say that based on intentional deprivation, unless there's full restitution, you're disbarred. And it seems like they may be right there because you don't pay the restitution voluntarily. You do it after you're caught. And two, you don't even pay it to the right person. You pay it to your client, who, based on your briefing, you apparently are continuing to represent in another case. By the way, is that going on when he gives the client the $8,000? Is he representing her in another matter? Do we have fact findings to that effect? No.
Well, no, I mean, that point was just made to say that the client was satisfied with Mr. Sargent and came back to him. That's the only point for that. But in regards to restitution, all right, this is a solo practitioner.
I get that. You've done a very nice job of trying to put this into a sympathetic context.
But I'm not doing that for that reason, Your Honor. At the hearing, Bar Counsel stood up at the hearing and said, giving the money back to the client was the right thing to do. So at the very least, there's some confusion.
Clearly not the right thing to do.
After 2 years, I agree with you, Judge. After 2 years, I agree with you. But then again,
Just to refocus you, I think Justice Kafker's point is, does it count when he only does it after he was caught? Should it count when he made restitution only after he was
Yes, Judge,
caught?
right. And again, that's why it's not one size fits all. All of the facts have to be looked at. And I agree, all right? I would rather be standing in front of you today saying that the money was returned a hell of a lot sooner than it was. But it was returned. And I'm sure you've had other situations when the money hasn't been returned even after Bar Counsel's been involved. The only thing I'm saying, Judge, is that, it's not part of the record, but as an officer of the court, I will tell you, and as a resident of Beverly, that this is in the front page of the Salem News, Mr. Sargent's disbarment. So he has suffered as a result of this. Maybe not in a discipline from the board, but he has. And it was just a bad situation that will never happen again. And there's evidence from on the hearing committee on that. He's hired a bookkeeper to address situations, and he's got help. And I just think it's wrong, and I just think it's unfair for one situation like this to cause somebody to lose. And it's not just his career, it's your lifestyle, his profession, because as lawyers, this means a lot to us that we can hold ourselves out as a lawyer. And I would just ask you, please, give him a situation where he can make amends and do other things.
Okay,
Thank you very much.
thank you. Okay, Attorney Mikuleski.
Good morning. May it please the court. I'm First Assistant Bar Counsel Joe Mikuleski, appearing on behalf of Bar Counsel in this disciplinary matter.
But before we get into disbarment versus indefinite suspension, the first question I asked counsel was the issue of mitigation, which is always something that puzzles me.
Sure.
And the tipping point between ordinary and exceptional, and I know there's the Bolero case where there's some mental health issues. Given the focus on attorney well-being of this court, is it time to revisit this? And can you explain to me what's the distinction between ordinary and exceptional?
Sure. If we're talking about financial stress and family discord, it can rise to the level of a special mitigating factor as opposed to a typical mitigating factor. But we already have established case law as to when that occurs. And so in matter of Sweeney, for example, the attorney's daughter was in a horrific car accident. Her life was at risk. He stole the money in order to get her health insurance, and the hearing committee specifically found that that saved her life. That's extraordinary. That's a special mitigating factor. There are a bunch of cases that we cited in our brief, Corbett, the matter of Gail Johnson, the matter of John Johnson, where they did not rise to the level of a special mitigating factor. And again, the board and the hearing committee aren't obliged to credit that. They can look at the facts and they can decide to credit it or not. And I think it's important to emphasize the procedural posture we're in here today.
But how do we, because I have the same question Justice Gaziano has, how do we, because this sounds serious. He's taking care of parents who are falling apart. He's had to give up half his practice. Where do we draw the line? I mean, I understand where you have to save your child that's really extraordinary, but
Sure.
Where do we draw the line here? You know, ordinary divorce obviously may be different. Ordinary tending of our parents. I just don't know what's ordinary, what's extraordinary, because I'm mostly focused on whether you guys are consistent or not, and I don't know how to apply that factor well.
Well, it's difficult to take a look at somebody's individual financial situation, familial situation, and come up with a general rule. And that's why we have case law that looks at different ones, and you look at those.
So why is this not extraordinary, Dick?
Sure. Well, first of all, what I'd like to go back to is for us to recognize the procedural posture with which we're in. The standard of review for this situation, this court has repeatedly said that it must remain mindful to give substantial deference to the board's recommendation. And under SJC Rule 223, it's the respondent's burden to prove that the recommended sanction that was imposed is either markedly disparate from other cases involving similar circumstances, or that there is some other reason that there's a manifest injustice. So that's what we're looking at. We're not looking anew at whether these factors would qualify as a special mitigating factor. The other thing to keep in mind is I would ask this court to be very careful of the facts of the case. There are no citations to the record. There are facts that aren't in the record. He can't have it both ways. He says that his parents came up in 2017 and that he had to leave the criminal practice. The misconduct, the misuse didn't happen until January of 2019. He was under this stress and familial problem for 2 years, and apparently nothing happened. The other thing to keep in mind is that he upplayed his financial difficulties in 2009 and downplayed his financial difficulties in 2020. The money was stolen in January 25th, 2019 through March of 2019. He paid his rent in January, February, March, April, May, June, July. He did not get an eviction notice until September of 2019. All right. So in those circumstances, with those true facts, did the board abuse its discretion in saying that does not rise to the level of extraordinary special mitigating circumstances? No, it didn't. So, again, getting back to focusing on what the respondent's burden is to show that this was a markedly disparate sanction. The first thing that he's hobbled by is that the hearing committee, the board, and the single justice all unanimously concluded that there was no restitution in this case. And as this
There was
court,
restitution, just not full restitution, right? He does.
there was
there
no
is-
restitution.
Meaning he never gave the money back ever?
He never gave the money to the correct party, and therefore there is no restitution. And as this court had pointed out just about 2 years ago in the matter of Williams, where there is ongoing deprivation, disbarment is the appropriate sanction. In other words, if there is not full restitution, disbarment is the appropriate sanction in cases. The respondent, and
So if he had written the check to whom is your position?
at that point, when he put the money back, it should have gone to Mass Health.
Okay. So so you're saying he gets disbarred because he wrote the check to mom instead of Mass Health?
No,
Oh.
he gets disbarred because he intentionally stole money that resulted in temporary deprivation and continual deprivation. There were aggravating factors and there were no mitigating factors. Because of all that, he deserves disbarment. And I want to emphasize that.
But let's just say he had written the check to Mass Health.
Sure.
Would he still be disbarred?
So there are a number of cases, as we pointed out in our brief, Corbett, Labasi, Dragon, and Hess, where full restitution was made and still there was disbarment because of the circumstances in those cases. And that's definitely what should happen here. The hearing committee and the board are not.
What about Strauss, matter of Strauss? How do you, there, we allow indefinite suspension, right? And that's a kind of a messy, not great performance by the lawyer in that one either, right? You know what I'm talking about, right?
I am familiar with the matter of Strauss, but that's not one of the cases that we cited in our brief, and that's, I'm a
But
little.
it's the latest SJC case, so why don't you address that one?
I'm not familiar with the facts of that case. I'm
Okay,
sorry.
Let me remind you.
Sure.
So, well, I don't know, it's a lengthy factual, I'm not going to go through all of it.
Okay, well, I will do a 16L letter on that. The point being is that even if there's restitution, full restitution made, it doesn't necessarily result in indefinite suspension as opposed to disbarment if there are other circumstances involved. Here, again, if we go back to Corbett and says, look, the point of restitution is that it's an outward sign of one's recognition of wrongdoing and moral obligation to make amends. That's not what happened here. As you full know, we were already looking into him. We had subpoenaed his bank records. We had corresponded with him for months. He never mentions it at all. While he's stealing the money. We asked for his financial records. He doesn't produce them to us. So we subpoena his bank records. Once he's alerted that we were subpoenaing his bank records, he asked for an extension of time to December 5th, 2019. We give it to him. The day before, he puts the money in and cuts a check to his client, knowing that the money doesn't belong to his client. Beyond that, what is very important in this case, and if you look at Labasi, which also cites matter of Bryan, the respondent has engaged in continuing misconduct. The judgment of disbarment was in January, and the respondent requested the single justice to have time to comply with the disbarment order of April 1st, 2024. He was required to do a number of things. He was required to stop practicing law. He was required to notify his client by certified mail, and he was required to provide this court with an affidavit of compliance. To this very day, he is not in compliance. He thumbed his nose at this court's order of disbarment. Now, in full disclosure, yesterday, Bar Counsel received a document titled Affidavit of Compliance, but it does not qualify as an affidavit of compliance. And if you look at the certificate of service, it wasn't served on the court, and I looked at the court docket today, and it hasn't been served on the court. And as you know, there's a petition for contempt that is pending. So given the fact that he's thumbed his nose at this court's disbarment order for an entire year, even to this day, even if you found that he gave full restitution to the correct party, which he obviously didn't, disbarment would still be the appropriate sanction.
Excuse me, counsel, are you aware of other cases that are similar, in a similar procedure or posture to this one? It's not clear to me what we should do with the ongoing contempt proceedings that are before the single justice, and my understanding is there's a hearing scheduled for that. So it's puts us in a bit of a strange position to be taking, anyway, I mean, to some extent we can we can, of course, take judicial notice of the state of the dockets, but
Yes, so I'm not aware of a case where there was a petition pending before the full bench, and unfortunately, we had to continue the hearing that was supposed to happen before this. But as you noted, you can take judicial notice of the fact that he has not, at the very least, filed an affidavit of compliance. So that alone is evidence that he's in contempt of the disbarment order.
But we can't, that question is before the single justice.
Correct, correct. But you can note that it's in the record that the judgment of disbarment requires.
But we're reviewing the single justice's decision that took place before these contempt proceedings, correct?
Correct.
So are you arguing that notwithstanding that we're reviewing the decision of a single justice, we should also consider the events that have taken place since the single
Yes.
justice decision?
Because that's happened in matter of Labasi, that happened in matter of Bryan. So in both of those cases, the court took into consideration ongoing misconduct, specifically that the respondent had failed to comply with the temporary suspension order or that the respondent in the Bryan case had failed to file the affidavit of compliance.
And in those cases, similarly, there was no court order so holding from the single justice in the meantime?
So holding him in contempt, is that what you mean?
Right. To me, it would seem different if the single justice had entered an order already.
Yes.
And in those other cases, was it a situation where we were just ourselves looking at what was happening below?
I don't believe that there had been a finding that that in those two cases, the attorney had failed to comply with the ongoing, but I'm not positive about that.
Okay, thank you.
Can I ask you to turn to your supplemental memorandum?
Sure.
I really just have sort of a conceptual question for you.
Sure.
You've proposed a very detailed list of factors with sort of a determinative factor at the beginning as to restitution. It reads in some ways to me like a checklist, and I'm worried about that, to be frank. I'm wondering why we should adopt a kind of checklist for the decision of cases that are, extremely fact-dependent, where we rely on the board to exercise discretion, truly informed discretion. These are not like, lay people. So can you please address that? In other words, I'm worried that by adopting a checklist, as you propose, that we are going to be qualitatively changing the nature of the decision-making.
Sure. Well, with respect to restitution, it really isn't fact-dependent. Well, in the sense of the four factors that we've suggested in order to qualify as restitution are pretty basic, and it is helpful to have a checklist to say, okay, do we even have restitution here? One, it has to be made to the correct party. I mean, there's no really discretion in that. If restitution is made to the incorrect party, that doesn't qualify as restitution. Two, it has to be full restitution. This court has already said that partial restitution is not full restitution. That was in a matter of Collins' case in 2010. Third, the timing and circumstances of the restitution should be taken into consideration. And so all of those factors are helpful in order to have some clarity, in order to have some consistency. Is when we're talking about restitution, what exactly do we mean?
Well, one of the things that, for example, your enumerated list doesn't take in, at least I didn't see it, was where the attorney does not have the ability to make restitution.
Sure. So then you would take a look at matter of Collins. So if you get to the situation where the attorney has not made full restitution, is there a situation where you can say, okay, but we're going to give you an indefinite suspension even though you did not pay full restitution? That's matter of Collins. But what happened there was the attorney paid partial restitution, and very importantly, he made an acknowledgement of his obligation to make full restitution, and even more importantly, he self-reported his misconduct. So if an attorney takes money, decides to report it to Bar Council and either makes partial restitution and/or makes a written, unequivocal statement that he has an obligation to pay it in full, then it could be an indefinite suspension if interest is made. And again, I think that's a very important point to make, that this court in Collins mandated interest. And that goes back long ago to 1882 when the Bowen versus Richardson case came out, talking about what the duties and responsibilities of fiduciaries are. And the bottom line is attorneys should be treated just like any other fiduciary, and certainly not better than other fiduciaries. Because if they were, it would undermine the public's confidence in our system, and it would definitely leave clients whose money was taken less than full.
Okay.
All right. Well, thank you. We would ask that you affirm the judgment of disbarment and adopt the framework in full. Thank you very much.